Hello, welcome to the Modern Divorce Support Group live office hours. I'm your host today, Billy Tarasio, attorney and owner of Modern Law. Here at the live office hours, anyone who is a member of the Modern Divorce Navigator program can come join and ask whatever questions you'd like, and we will brainstorm and we will talk about your case. This is not the substitute for legal advice. I do not become your attorney, and we do not develop an attorney client relationship from the live office hours, but we can use this time to brainstorm, talk about your case, come up with ideas, and hopefully better represent yourself. McKenna, welcome to the show. How can I help?
Hello. I was on call yesterday. I lost a case recently for final decision making and parenting time. I have a great co-parenting relationship pretty much up until now. The father petitioned for final decision making, so she now goes to a school 45 minutes away from me.
Mm,
She has siblings. I just read the final order from the judge, and there's nothing in there that I can even see as to why he made the decision he did. I naively thought that justice, like it was just an obvious case because of the siblings, and my school that I presented offered a 1 day adjustment to our parenting time versus his, which completely changes my work, everything, just completely changes my life and hers, because instead of having more additional time with myself and her siblings, she will now be in school 7 hours a day instead of being half day or time with me. So the question I have is, I'm still debating on whether filling out a reconsideration based on best interest statute, because I just am like, is it worth it? But I'm already in worst case scenario. The question I have today is, how does child support work? Because we have a child support order that I never touched because of our great relationship. And now I'm going to, because I'm upset and I'm about to be traveling every day to be near my child. And I cannot believe that he has decided for strangers to be with her over me. And it's like, I just, so we have an order in. He recently switched jobs, so I don't know what his income is. His income is about 2 grand more than it was when we first filed. And I just am like, how do I
okay. All
go
right.
about
So,
that?
McKenna, is it okay if I ask some questions?
Please.
Okay. So, what was your previous parenting plan?
So scheduled in our stuff, because we were never together, we were never married. He filed just to have his rights to her. We never even went to court. I signed, everything looked good. In the agreement was 1 week on, 1 week off. For the last 4 years, we have been doing, I had her every Sunday after 11 o'clock till Wednesday at 5 p.m. He had her Wednesday from 5 p.m. to either Saturday at 11 or Sunday at 11, because we alternated the Saturdays.
Okay. And then I'm assuming who filed to modify?
He filed to modify because he wanted her to go to school down the street from him,
Okay. And how far apart do the two of you live?
about 45 minutes.
Okay. Okay. And
And I'm in
then,
her home base home where she has started life. And he moved several times. And I made a mistake because I just thought it was all about Luna's best interest. And he's a good dad. And I didn't want to go after him and be like, how many times have you moved? And da 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 da. And I just didn't. And like,
so
it's just,
the court was choosing which school she would attend.
they chose which parent got to choose which school she could attend.
Okay. So dad got final decision making.
Correct.
Okay. And, and she's going into kindergarten, or she just started kindergarten?
She just started kindergarten.
Okay. Okay. So you've got this child support order for how much?
So right now it's $200 a month.
All right. And that goes back 5 years or something?
Yes.
Okay.
Well, it goes back 4 years from our original filing date.
Okay. And he has never paid.
No, no, no. He is paid.
Okay.
He is paid. It's just, I never modified it because I thought what we were doing was fair.
Okay.
But now I'm going to be traveling
Okay.
far distances. I have to put my children into different childcare. Like, it's just uprooted my life. And I know that when you can modify an order when there's been a 15% change or circumstantial. Like my two other children aren't a part of that order.
Okay. So to me, like, why did this go to court? Why? I mean, the two of you had been working things out for
Yeah.
5 years. Why did you decide it was a good idea to just be like, I'm going to go to a judge?
So I didn't, he did. I had offered different, I offered different schools. The school that I focused on because it gave us the flexibility that we have known our whole lives. Like, hey, can you grab her? Like, we changed our schedule all the time to fit our needs with one another. We were the whole thing. And
Why
his,
didn't that work for him anymore?
I have no idea. And every time I tried to talk to him outside of it, he would be like, let me get back to you. Or, we did the mediation. There was just never any back and forth when we went to court. I even said, I was like, if this is about the best school, which I never believed it was about, I believe it's about proximity to the school. If it was about the best school, I had three of the best schools within 15 minutes of me. He has one. That's number 17. Like in my area, I had number 1, number 4, number 6. Like the only reason I focused on the school I did was because of the flexibility. And his was number 7. I have no idea what happened.
And the judge didn't say why he ended up giving dad final decision making?
Nope, there's nothing in any of the paperwork. He didn't ask any questions.
He
Nothing.
analyzed the best interest factors, right? He has
I
to.
mean, I feel as though they didn't because I don't understand how her not going to school with her sisters is not in her best interest. Like, they're her sisters. Now she's not only separating and being lived between two homes, but now she's going to have two total separate routines than hers. How does that not make a child feel different?
Do you have the order?
Yes.
Can you share it?
Yes. You mean just like what it says?
Yeah, it'd be really helpful if I could see what it said.
It's, it just, oh, are you still there?
Hmm.
Okay.
Yeah.
It says that we both have final decision making. I mean, both have joint decision making on school educations, but where we can't agree, father has final say. That's
What
like it.
what I want to know is it has to analyze the best interest factors. That's required in order for, otherwise
Okay.
it's appealable.
Okay. The
So there are
order.
13 best interest factors. Judges are not allowed to enter awards without talking about them.
So this says an order part 1 of 1. That's what I'd be looking at, right?
Is this a, can you send it to me?
Yes.
Or put it in the chat or share your
Absolutely.
screen?
Yes. Let me see if I can share. Is sharing my screen just as useful?
Yeah.
Okay. Um. Oh, I don't know how to do that.
Okay.
Oh, wait. Would that just be through? No.
Okay. So
I can send it though.
okay. Um,
Oh, best interest findings.
mhm.
Um, Basically everything was like even, even, even. Neither neither parent took an objective on a reasonable position. I'm even trying to figure out. Is there an email that I should send it to?
Let me see if I can chat it to you.
Or am I, can I just copy and paste?
Oh, it won't allow me to chat it to you. Okay. Um,
Because I just read it this morning.
you just got it this morning and read it this morning?
Yes. And you said it's the 12? Okay, yeah, the 12. The past, present, and potential future relationship between the parent and child. Both parents have a good relationship. The interaction and relationships of the child's parent or parents, the child's siblings, or any person who significantly affects the child's best interest. In addition to what is stated above, the child has a good relationship with father's girlfriend and mother's extended family. And it's like, yeah, we have a good relationship, but that doesn't change the fact that this order is going to completely change everyone's access to her. Like my mom, like my dad and my stepmom live down the road, her aunties live down the road, and now everybody has to drive 45 minutes to be a part of her versus one parent having to drive 45 minutes. It's like his family's in a different state and his girlfriend is his girlfriend. She's not his wife. And I mean, it's just
Okay, so there's nothing in the order that indicates why he decided to give dad final say.
Nope. Everything is like equal, equal, no credible evidence, no credible evidence, no credible evidence for like the last three.
Okay. All right. Well, your options at this point are to contest the order, live with the
Right.
order, or try to negotiate with dad.
Right.
And you definitely have a child support modification as a potential way to negotiate. Um, the first thing would be to run that child support calculator and see how much it would change now.
So if I don't know his income, then I would have to ask him for that first.
Mm-hmm. Yep.
Right. Now, parenting time was not affected by this order.
Okay.
And we have decided, and this is the only like in that I felt like I found, because now we've changed it to where I have her every Thursday evening, Friday, Saturday, and alternating Sundays, so that I still have that joint time. And I have a feeling that quickly her dad's going to figure out how much time he's missing out on her not having weekends with her
Got it. So
outside
so
of the
is
school
that
week.
is that parenting time plan in the court order?
No, he just agreed to it yesterday.
Is it in writing?
Yes.
But your parenting time order in the order is week on, week off?
Original, yes, which
All
we have
right.
never done.
Right. So any moment in time, he can go back to that and say, I want to do week on, week off.
Right, but wouldn't he have to take me to court to
No,
enforce it?
no, that's the court order. So
I would
you're
have to then take him to court to change it.
right. And you can't for a year because you just had a trial.
Oh, no, so the parenting time was not part of this trial.
Only
It was
decision making.
only decision making. So then I'm like, do I go and put it in and have him agree to it to be like, I just don't want to have to mess with this. And I just want it to be all good since we're doing stuff through the court now. That way I'm covered. Because I have a feeling he's a great father. There's no, you know what I mean? This is like, I don't know what happened. He's an amazing father. I have a feeling that his girlfriend has weighed in and that they're going to see this as we get our weekends off, we can go and do everything, but I truly believe he will quickly figure out that the school week is different than the weekends and that he'll want it back. And I would like to have that as leverage for either picking a different school for her or just some kind of security, because it's like the parenting time was not a part of it.
Okay. Um, you may want to file your stipulated agreement for the change in parenting time and just put it on the record. That might be
Okay.
something that I would consider doing, just updating the court like this is now our official parenting plan that we're agreeing to, because that's going to make it a whole lot easier for you to enforce. And if you feel like, fine, I don't love this, but I can live with it and I don't think it's going to be this way forever, then that's probably what I would do is start right there.
Okay.
And then, you are absolutely free to pursue a child support modification as well. I would make sure you get this stipulation for a change in parenting time filed first. Okay.
Yes, like keep the yeah. Okay.
All right. Thank you, McKenna. If we
Thank
have
you so
time, I'll
much for
come
your
back.
time.
Yeah,
I
no
appreciate
problem.
you.
Bye. Jessica, how can I help today?
Hi. I have a couple of questions, but I'm basically at fairly the beginning of the process. I had a temporary orders hearing for divorce and custody. It did not go very well. We didn't get to address very many topics. Um, my biggest concern is so I'm expecting our fifth child. I'm due in November, so everything is kind of on hold for us. We have a status hearing in October, a couple weeks before I'm due. I have no idea what to expect. I don't know what status hearings are usually about. And then I have some concerns because he's hiding income, and I didn't get to address it at all at our temporary orders. So I didn't get to ask for spousal support, and child support is based on half of what he's actually making. And so I don't know how to address that or if that can be addressed at the temporary hearing.
Okay, so
And then my other big concern is just the baby and overnights when the baby gets here.
yeah. Okay. So this is a divorce, right?
Correct.
And you filed a petition for temporary orders or a motion for temporary orders,
Correct.
and you
Yes.
asked for child support.
Yes.
Did you ask for spousal maintenance in that temporary orders motion?
I did, yes.
But
But we didn't address it at the hearing.
Do you have your ruling yet?
I do, yes. It just states that we didn't discuss it, so no decision was
Okay.
made, but I'm not prevented for asking for it in the future.
Okay. All right. So you could do a motion, a request, a motion to set a trial for a temporary orders hearing on the issue.
Okay.
Nor-
So just be like a new temporary
Yeah, now,
orders
normally,
specifically on spousal maintenance?
You're responsible to cover and to address every single issue during your time in trial, right? Normally, that's the way it goes. So
Yes.
I don't think the court has to give you another temporary orders hearing, but it doesn't hurt to ask. And you can explain why it's important and why you need it. Although I would try to negotiate with dad first.
Okay, yeah, that's not
Okay.
possible, unfortunately, in this one. But is that something that can be addressed at the status hearing, or
No.
is no new issues are brought at status
No,
hearing?
you have to ask for an
Okay.
evidentiary hearing. Yeah, you can't just present, but you could file a motion to convert the status conference into a temporary orders hearing on the issues that you didn't address. So you could ask for either a new hearing
Okay.
or, in the alternative, ask that the status conference be converted. You could absolutely do that.
Okay, and if none of those work out, then it's just something that would be addressed at the final evidentiary hearing of the actual divorce.
Exactly.
Okay.
Now, income. What does
Okay.
he do?
So he has a 9 to 5 in finance. That is what he claimed as his only source of income. We opened a business together, and it had been running for the past 3 years. In the last year, it really took off, and we've made over 100,000. I have bank statements that have over 80,000 being directly deposited to what was our marital account, but unfortunately, it was only in his name. There's a lot of financial abuse involved, and so I have documentation basically up from April of last year to April of this year. That's when we separated, so I don't have documentation since then.
What does the
I
business
did
do?
not get, it's a moving company.
Okay. And does he run the business and do the moving?
We both ran the business when we were together. He also does some of the moves. He doesn't do all of them. Some of them, we do have other employees who go out and do the moves.
Can you stay involved in the business? Like, do you no longer have
No,
access?
I've been locked out of everything.
But your name is on this business?
Correct. So I do own like the business domain. I have the website. I have the LLC filing and all of that, which my name is on. I just don't have access to any of the financial accounts or customer communication. He's kept all within his own phone number and that kind of thing.
Is it an LLC?
It is.
And is he the managing member?
I would have to go back and look, but I believe either I'm the managing member or we both are, I think. I don't.
Okay, so I want you to go look, because if you're the
Okay.
managing member, you can walk into the bank and as the manager, you can change that access.
Well, it's his personal account. So he has like Venmo and stuff set up as the business.
You don't
I
have a
believe.
business bank account?
We did, but he didn't. He sent everything to his personal. The business bank account remained empty. He had all the transactions directed to like his personal Venmo and then sent them to the bank account that's in his name.
And he set up all the software and he has access to all the customers and you don't?
Yes. Yep. For all the financial,
There's
like
no-
social
there's
media,
no way that
he's
you
blocked
can-
me out of all that.
Okay. Okay.
No, I'm basically like sneaking, trying to make profiles to prove that he's still actively advertising on social media and like getting Google reviews and all of that to prove that he still actually is working.
Okay, so you have this evidence. Did you present it at the temporary orders hearing?
No, I didn't get to. I didn't understand the timing and all of that, and
Okay.
so I focused on the child issues. We didn't get to finance or anything.
At all, but you have child
No.
support.
Correct. Yep.
Okay.
But she just took his word for what he was making.
Right.
And I was out of time, so I didn't get to like
Yeah.
cross-examine or refute and give my evidence or anything.
Yeah. Okay. If you get another temporary orders hearing, you'll have the opportunity to present your evidence. That would be really good.
Okay.
You also have the ability to do discovery. We have specific classes in the Navigator on how to do discovery.
Okay.
And I think discovery in your case is going to be very important. You need to collect evidence and you need access to information.
Yes.
So then the other question you had was about your baby. Do you feel like the current parenting plan that you have with the other 4 kids is okay and working?
No. We have 2 that are school age, and then we have a 1-year-old and a 4-year-old. And currently we're doing 5-5-2-2 because that was what he requested. I don't think it's great for our youngest. Otherwise, I do think it's okay because the time that I don't have them is the only time I'm able to pursue financial freedom and, security.
Yeah.
But I don't think it's great, and it definitely wouldn't be great for a baby. I
Right.
nursed all of our newborns for at least the first year, if not more.
Yeah.
And I'm just concerned that he'll be spiteful and try to take overnights and stuff.
Do you think he would?
Yes.
I mean, taking care of
He's
5
done everything
kids
he can to punish me and
for leaving?
forced me. Yeah, he cut off all my finances and left the kids and I with no money, no food, and everything. And then just kept saying, "Hurry up and file for divorce already. Hurry up and file already." And it got to a point where I had no resources, so I did have to file to try and get some help. And then he, of course, had all the money, so he lawyered up, and I couldn't, which is why trial went so sideways, because I was well prepared, but I didn't know what to expect time-wise, so I didn't get to present all of my preparation.
There's another course inside the Navigator that every single person needs to take before they go into trial, and it's called the Trial Skills class. Every single person. I'm saying this not really for you, Jessica, but for anybody who's listening. You have to watch the Trial Skills class before you go into trial, because what happened to you, Jessica, is common and so easy to have happen. It is going to be on him to request an order for parenting time with your baby.
Okay.
I think you just don't bring it up.
Is that addressed at the status conference either then?
No.
Oh, okay. What is addressed at a status, like what's the point of it then, I guess, if we're not talking about issues?
The status conference is, what's the status of your divorce? Have you all worked it out? Have you gone to mediation? Are there issues that we can take off the table? Do we need to set a trial? You're going to need a business valuation. Your case is complicated. You're going to need a business valuation. You could consider filing a motion with the court to ask the court to appoint someone to do a business valuation and have the business pay for it. That's a good idea, because you won't have to pay for it. And then you hopefully will get information from that person. They can go do discovery on your behalf, and they can get income information and evaluation.
Okay. Wonderful. I guess my only other concern then, which it sounds like is not going to be an issue, is regarding our home and our living arrangements. So I don't have to worry about any changes to that at the status hearing then, right? They're not going to change. He wasn't ordered to return to the house, and part of my fear was that he would try and request that at the status hearing before the baby comes.
No. Were you given exclusive use?
No, I wasn't. It's actually, the house is in his name, so I'm going to have to move out once things are over. But at this point, he's not
So there's nothing
ordered
preventing him from moving back in?
No, she just said a return to the home is not ordered at this time. So I don't know that she's presenting it or preventing it, but she's also not requiring it.
Right. Okay. All right. So Jessica, if we have more time, I'll come back. Okay.
Okay. Thank you.
All right. Beth, how can I help today?
I am. Well, I'm headed in toward the modification hearing in a week, and so I will be taking that trial skills class because I'm a little worried about time. I'm sort of wordy, and I've asked something about this before. You said go look at the list of things that it's mainly about spousal support, and what are the list of things in California and Los Angeles that are looked at? You with me? Am I making sense yet?
Yeah.
Okay, so I'm trying to make a decision about, there's a half a, not half, there's, like 10 different things. And I'm not going to have to talk about all 10 different things. That would take forever. So I'm trying to decide what to hone in on to to talk about.
Right.
I mean, the duration of the marriage is listed on the forms, but I might want to state that the current, I mean, I think the first thing I'm going to say is that the plan that we already have in place is a good plan, since the duration of the spousal support is already less than half of the marriage. That makes sense.
Right.
So,
So
but just mention it in a sentence, right?
he's trying to modify, right?
He's trying to stop paying spousal support. Yes.
Sure. So there is a statute on what has to happen in order to modify. In Arizona, it has to be an unanticipated change in circumstance. It's not a redo of the original spousal maintenance. So you're not looking at the original spousal maintenance factors. You are looking at what has to happen in order to get a modification. And if he doesn't get over that hump, probably you have to look at your statute. But it's going to have a requirement that he has to meet before he even gets to ask to modify. So you want to defeat that
So
first.
some sort of significant change in circumstances.
Is that what your statute says?
That's a good question. The rest of it, when we were talking about child support, it was a significant change in circumstances. I'm not sure if that's the exact same wording that it is for spousal support.
Yeah.
I don't know. You're asking
Definitely
a
want to
question I
look
don't have the
because
answer.
in Arizona, it has to be unanticipated. So like, it doesn't matter. Like, if you make more money or if you make less money or if somebody went on to go get remarried, like all of that is anticipated. It has to be something like real weird, like somebody is now disabled and can't work anymore. And that's a good reason. Unanticipated. Nobody saw it coming. That's a good reason to change spousal maintenance. So look at your statute because you may be helped out by that statute in California. Child support,
Okay.
the bar for modifying is much lower. You just need to change the circumstance because whenever it's in the best interest of the child, you get to modify child support.
Okay. So he did exactly what I expected him to do. And but when the income and expenses came in, I was like, got scared again. So he did buy a house that's twice the worth of the house
Yeah.
that we had.
Yeah,
And I'm
his expenses don't impact your child support or maintenance. And you just want to hammer that
okay.
again and again and again. So the statutes are your friend here. He has the burden of proof. He's the one asking for a modification. Don't talk about this on his terms. So he has a story he wants to come in and say, I can't afford it because I can't afford it. And you're going to say, there's nothing in the statute that asks, can you no longer afford your child support? That's not the way this works.
Mm-hmm.
So you are not going to play his game. You're not going to get into the tit for tat or the argument he wants to get into. You're going to let the law outline your strategy and your argument, and that's going to dictate what evidence you put forth. Because you started out by saying there's 10 things I could talk about. You only talk about things related to your specific strategy. And that's what that trial skills course will help you figure out.
Okay. He's going to also, based on what the forms have said, the responses, is that I haven't built my business as fast as I should have, that I'm like lollygagging around.
Have you thought about doing a motion
Do
to
I need to come
dismiss?
in prepared? Huh?
Have you thought about
I'm
doing a
sorry?
motion to dismiss?
No, I haven't.
That's the first thing I would look at. I would look at what's required in order to file for a modification of change in child support and a change in spousal maintenance. because the things that you're talking about would not qualify here. And so if you don't qualify to ask, you motion to dismiss. You do not move forward.
Okay. Well, I wish I'd thought about that a long time ago. Okay.
That's okay. That's why we're here, right?
Okay. Yeah.
So nothing in the
All right.
statute
So I'm
says,
not going to go put my whole strategy. I'm really just defending against his strategy.
well, yeah, you're the respondent. So he's got a burden of proof. And like nothing in the statute says, nothing says when you receive child support, you are expected to go out and make more money so the child support can go down. That's essentially his argument. That's not a legal argument because that doesn't exist. There is no obligation for a recipient.
But for spousal support, there is some sort of, I forget what the little law is in California, that you are expected to be working toward being able to be self-sufficient.
Right, and that's why your original spousal maintenance order had a term, right? It didn't last forever because you're expected to become self-sufficient.
Right.
So that's already been
we aren't there yet. So
wrapped in, yeah.
Okay.
Yeah. Find out if you can do a motion to dismiss. Okay. Thanks, Beth.
All right. Thank you.
Jamie, how can I help today?
Hi, Billy. I am battling some bad service, so I'm sorry. I'm a client of Kylie's, and my divorce is final. However, due to like the equalization, my ex-husband owes money and he's not paid anything. We did get the judgment and it's been recorded.
Okay.
And then there was another asset that was up for dispute on valuation. And so the judge did make a ruling. But she did not give a judgment on that. So the first amount that the judgment is on is about 29,000. The next amount, 6,500. Like I said, there's no judgment on that one, but he is self-employed. He's made no effort, to pay anything, and he's just waiting for me to give up. What can I do? Like liens? I'm just not sure. We've kind of I haven't, had pressing matters where I've talked to Kylie a lot.
Yeah.
And just I want to try to figure this out as much as I can to save some money too.
Yeah. So you're in collections territory now, right? So you can't really garnish somebody who's self-employed because they're responsible for their own thing, unless he has HR, is it a big company or is it a one-man show?
Just a one-man show.
Yeah. Okay. So it's really, really, really hard to collect from those people. Does he have assets in his name?
Yes, that he's got, vehicles. Yeah. Basically, that's it. There's no home, but they're not paid for.
Yeah. I mean, you're a creditor at this point.
Right.
And it's kind of, sometimes it makes sense for you to go see a collections attorney because family law attorneys are not specialists in collection. You need like a repo man, right? You've already got a judgment. Now you need a lien, or you need to know, hey, am I allowed to go seize this property and take it because I'm a lien holder? You might, I don't know. I would maybe chat with a collections attorney and see, what can I do? Can you slap a lien on his house? The nice thing about slapping a lien on a house, if they owe it, is that you will eventually get paid because he won't be able to sell it without paying you.
Right. And he doesn't have one.
Oh, he doesn't have one. Yeah, of course.
Nope. Mm-hmm.
Retirement accounts? Does he have retirement accounts?
I'm not even sure. I always thought no. He said yes, but that wasn't even addressed like in the divorce. Yeah. So, and it could be substantial. It was BNSF.
It was what?
It was like Burlington Northern, the railroad.
Okay. So have they been subpoenaed?
No, they never were.
Okay. So you could do an enforcement action and subpoena them to find out if money's there.
Okay.
And again, if you want to do this yourself, then there's a discovery class you should take.
Okay. Take the discovery class. the enforcement action, would that be something through Riley,
Enforcement
or would that,
enforcement is through family court.
okay,
Like collections, like you've got the judgment and you need to figure out how to get the stuff. We don't really do that in family court, but if you want to find the assets, you can do that in family court. You can file a petition for contempt, a petition to enforce, and then you can do the subpoena. Now the downside is if we subpoena and it comes back with nothing, this is one of the worst parts about having somebody owe you money who hates you and doesn't want to ever pay you and isn't accountable to anyone and doesn't work for anyone. It's
right,
impossible.
right. So if I were to do a lien on,
Mhm.
his truck,
Yeah.
say that, that would be through a collections attorney. This isn't anything I could do.
Yeah. Because like you kind of want to go repo it if you can.
Yeah, absolutely. Okay. So, collections attorney, just
Collections
find
attorney.
one.
Yeah, find one. Talk to one. See what
Okay.
they got. See what they can figure out for you. Like they're pretty good at finding money. Like that's kind of their whole thing, you know?
Okay. And as far as the ruling on, that lesser amount, I'd have to do the whole enforcement
Make it a judgment.
again
Yeah.
for
Yeah, make it a
get a
judgment.
judgment.
Yeah.
Okay. Okay.
Thanks, Jamie.
All right. Thank you.
Daniel, how can I help today?
Hello, Billy. I'm speaking through a Bluetooth speaker. Hopefully you can hear me all right.
I can hear you.
Excellent. Yeah, I was talking with Tracy yesterday. I believe that's who her name is. I'm new to the group, so hopefully I got the names right. Mostly I just need some grounding and kind of guidance on how to navigate where I'm at. So I've been divorced for a few years now. It was finalized in 2022. I have 3 kids. The oldest is going to be 11 in December. My middle child will be 8 later this month, and the youngest is 5. Mom and I have difficulty communicating and working out decisions. Speaking with Tracy yesterday, I shared how it's taken 3 years just to make a religious decision. And it's not that we necessarily disagreed. It's for our child. What was the issue? It was ultimately how it was going to be done. And about a month and a half ago, I petitioned to change decision making and parenting time with that religious issue being one of the key issues, because Mom and I couldn't agree on a particular date. It was dismissed because the petition was earlier than 1 year since our last orders, because this issue was litigated last year. Anyways, I was trying to go for grounds of non-compliance because there's some other issues with school attendance, but just on this subject first, Mom and I, just fast forwarding here, Mom and I were able to finally agree on a date for our child's baptism. And so that issue isn't really an issue anymore before the court. However, the fact that it's taken 3 years and then that there are significant school absences, a pattern of this for the last few years. Mom has had like 20 plus absences on her time alone for the kids. And I'm trying to determine whether if it's even worth repetitioning because, we finally got a decision. But I really question if decisions taking 3 years is really in the child's best interest. If, he's still relatively young and I still have 2 other kids. And, if this is going to be what is acceptable to a court, that, hey, even though it takes 3 years to make decisions together, and even though Mom has 20 plus absences, I'm just trying to figure out what I should do in this situation, because it seems like there is not enough to convince or persuade a judge to change anything, but it's been very difficult to work with this with the ex and dealing with the stress of this, because
Yeah.
it just seems like issues prolong and they're not really taken seriously or genuinely.
Yeah.
So,
So,
yeah,
Daniel, how has the only way that a court is going to come in and change an order is if you're going to be able to show direct negative impact ongoing to your children. So, if you can go in and you can say, my child is failing school. I've got teachers saying that they're struggling and they can't learn the material because of absences. I've worked with mom to figure out how to fix the problem and we can't. And the child won't be able to be successful in school unless we change parenting time. That is the only way that a court will get involved. A court's not going to get involved and say, yeah, dad, you get more parenting time because mom had absences, unless you can directly show a negative ongoing impact to your children.
even if I'm not going for extra parenting time, but rather a change, like, so right now we have equal parenting time, just a change in exchange schedules. Because it is, even though I petitioned about a month and a half ago, it was out of time, or wasn't in the timely period. It is now, so I could repetition at this point with meeting the 1 year. It's just, even though it's my concern that they do have absences, my oldest, he's a brilliant kid. I'm not saying that to
Yeah.
because bias, but he's even though he's had several absences, I think last year he had 26. He is not failing anything. He has A's in all of the classes. He's a smart kid. But my middle child, however, was struggling in just a
Yeah.
few subjects, but she was doing just fine. So I
Yeah.
can't really point to harm except that the kids are being, suspiciously sick is what seems to be the excuse, but also that school seems to be deprioritized. Mom doesn't like the school that they go to, and so it seems that there's any opportunity to kind of minimize or diminish the importance of school. It seems that that's what she's doing. That's really hard to prove, but I mean, what I'm looking for, it just regardless of that, I would like a change in schedule where we do exchanges, and particularly, I'd like the exchanges to be done at school instead of at a police station, which is what she
Ugh,
prefers. So
awful. I mean, it seems like you guys should be able to agree to that. I don't think that fixes the absence problem, though.
she's not amenable to anything I propose. It is her way, or
So,
it,
what type of parenting plan do you guys have? Is it a week on, week off?
it is a 5225.
And exchanges happen at the police station?
Yes,
That's dumb.
agreed.
Exchanges should absolutely happen at school.
Yes, and to add some more context to that, so my youngest is 5. She just started kindergarten. I believe the judge did not. This was the reason for my petition last year, was to harmonize the exchange schedule with the school schedule. The judge, I think, in my personal opinion, didn't do that because the youngest was still not in school.
All
So
right.
I
So, your
wonder,
change in circumstances is everybody's in school and now we need to change the exchange location?
that's what I, yeah. And so I believe that could be a threshold enough to just change the schedule.
Yeah,
Uh,
I don't disagree. I feel like that's kind of a no brainer.
okay,
I can't even believe that mom wouldn't agree to that. Nobody's going to see anybody. It is the easiest way to exchange for kids. It's not disruptive, you know. They have to go home from school. They just go home with whatever parent's day it is, you know. But
right.
I don't think that that fixes or addresses the issue of decisions take too long or there's too many absences.
I know that doesn't directly affect it, but it's
But it's a very reasonable request.
okay. Yeah, and I would have to leave it up to the judge because I mean, in my opinion, yeah, the absences are not isolated to just last year, but I mean, this has been consistent since they have begun going to school before. During the marriage, we did homeschool, but that doesn't really work in our situation now, being separated, and just high conflict nature. So I was awarded final say on the school originally, and then the judge last year after litigation just gave us both joint decision making with neither having final say on any issue. And so it's ever since my youngest going to the school, she pushed to change the schools, to schools that were just closer to her without any real legitimate reason to change, like, hey, the kids don't do well here or anything like that. It's just really, it was just because they were closer to her. Anyways, it without any really supporting facts, she just kind of capitulated. Fine, you can just enroll them at the school, enroll our youngest at the school, and she didn't really. And so, I mean, it's not an issue, but what I'm, I guess, trying to portray to you is that she's not really intent or genuine, I guess, about their education. And I do have concerns that if the pattern lasts long enough, then yeah, they will eventually begin to have struggles.
So generally speaking, you cannot get a court order based on a potentially bad outcome.
Understood. So are you saying then that the past absences are not enough, and because of they aren't really struggling?
It's not related to decision making, it's related to parenting time. It's not a legal decision whether or not your child goes to school on a given day. It's just a parenting time decision. So then the question is mom's judgment, which is different than your judgment. In her judgment, she doesn't consider school to be that important and she's not making them go, and there's a lot of absences. Is that decision making on her behalf so bad that a court's going to take away her parenting time? That's your question.
Not necessarily. It's more that they could, and you're right, I agree. It's probably would need to wait until the kids begin to struggle before
Which sucks, but that's kind of how the court works. They're not going to come in, they're not going to change her behavior, you know, which is really what you want. You want the court to be like, lady, your kids need to go to school.
Right, but again, the absences still have statutory consequences.
Right.
Surprised the school hasn't done anything about saying, look, you know, pursuant to ARIS, whatever it is about the truancy and stuff.
Yeah.
And that's where my worry is that I think she's intentionally doing this to some degree to see if the school would just, on their own, dismiss our kids and force us to do something else. Because that is a potential consequence.
Excused or unexcused absences?
They are marked excused, but they're dubious because like every excuse is, oh, they're sick, and then they're not really sick. There's no corroborating medical records to show that they're actually sick. She just claims they are, but then doesn't really communicate to me either. So I don't know. I'm left in the dark on what is actually the real reason.
I mean, I think what I would recommend is that you definitely like create some evidence. So every time your kid's sick, I would be like, hey, what's going on? I have concerns about absences. This is the XYZ date. What's happening? How do we get her into a doctor or him into a doctor to make sure that their immune system's functioning well? Like, put some pressure on mom every single time. You're creating exhibits, and you may be able to change behavior that way.
I'll give that a try. We'll see. But hey, I don't want to take all the time, Billy.
Yep. Thanks, Daniel.
Yeah.
Chu, how can I help today? Hi, Chu. Are you there? No? Okay. We've got about 10 minutes left. Who has questions?
I've got one.
Was that Beth?
Yes.
Go ahead.
So I looked it up. It does not say unexpected. It's significant change and circumstances that are substantial and ongoing.
Okay. Well, does he meet that requirement? What are his proposed change in circumstances?
That's a good question. I will have to go and look at what he said, but I think I think what he's proposing is that I'm making more money.
Okay.
I'm making a little more money, but I don't think, I mean, the point was for me to get to the place that I'm self-sustaining, not let's cut it before then.
Is that a significant change that is, what was the word in the statute? That was ongoing?
Substantial and ongoing.
Substantial and ongoing. So if you're only making a little bit more money, that's not a substantial change. I would still file the motion to dismiss.
I have one.
Go ahead, McKenna.
With school education final decision making, if I on my parenting day, say a Friday, want to pick my child up early, there should be nothing that has anything to do with him and his permission to do any of that because it's within the school guidelines. I'm mom. Is
No, you're
that
right. You're right. That's a parenting decision.
right? And I'm allowed to. It's like as long as because I'm just listening to Daniel and I'm like, well, I'm not going to be doing that, but like I have the freedom to make decisions on her school days that are my days.
Yes.
Beautiful. Thank you so much for your time. I appreciate you.
Yeah. It only becomes an issue when it's a negligent pattern that has
Right.
a negative impact on your child. But on a day-to-day basis, like if you want to take your kid out of school to go to a concert in
Right.
another state,
Right.
that's your call. That's your
Okay,
call.
cool. Okay, cool. Thank you so much. I appreciate
No
it.
problem. Who else has questions? Chu, I can't hear you, but if you want to post it, if you want to type your question in the chat, I will certainly try to answer it. Daniel, did you have a question?
I did. I have, so I guess the other follow-up question to what I was asking earlier is last year too, I would like to have a downward modification in my child support obligation. Mom is a registered nurse. She has a master's degree in nursing, but she chooses to underemploy or not work really. Last year she said that she needed to maintain a flexible schedule for the kids, and so the court awarded or attributed her minimum wage, even though she's has all the qualification as ability to work. Um, I believe this could be another issue to bring up and to modify child support. I guess what I'm looking for is there's no way to really get information of her earning potential because she doesn't work or she's just underemployed. So I was thinking of
You
maybe
could
using the
do
Bureau.
something called a vocational assessment. So this is what we do when we need to prove that somebody is underemployed. And, you know, you hire an expert who does a vocational assessment, and they will make a report and testify to the court how much this person can and should be earning.
Okay. How do you how expensive are these
They're not too bad. I mean, it does make sense for you to do the cost benefit analysis, but you can usually get them done for $2,500.
Okay. All right. Do you have any recommendations? Are you allowed to say that over here on this?
We usually use a man named Brad Taft. There's probably a few others, but he is the one that we end up using.
Brad Taft?
Yeah, you can find him
Okay.
online, I'm sure.
Okay,
Okay,
thanks.
Chu did write in, and I want to make sure to answer their question because they don't have a headset. All right, there's an order in place that has been closed by the judge. However, the OP, the opposing party, is to complete a DA. I don't know what that is. And complete all recommendations by the professional by July 2025. I requested an update on this and I haven't gotten a response. But there's high conflict dynamics with the opposing party and I don't want to send more communication. The order states that no motion can be filed until mediation takes place. What do I do about this part of the order? Because it does put the child at risk. As it stated in the evaluation, the child is becoming the caregiver. I'm trying to understand the question. So the court issued a parenting time order after an evaluation, and in one of the provisions of the order was this parent needs to do XYZ by this date. The date has passed and they haven't done it. What can you do? You can file a petition to enforce.
Yeah, the DA is the diagnostic assessment that she was supposed to have done by a certain date.
Okay. And how old is your order?
The order was is about like 3 months.
Okay. So it's too soon for you to file to modify, but you could file to enforce.
Okay.
Is that helpful?
Yeah, that was I was just trying to figure out what steps to take in
Yeah.
order for this DA to get done.
Yeah. I do have some other questions here in the chat, but they're from non-members. Linda and Alicia, I would absolutely recommend that you join the Modern Divorce Navigator. It's inexpensive, free for the first 7 days, and then you have live office hours with me and 2 other attorneys 3 times a week. So you can come and ask your questions. Just go to navigator.mymodernlaw.com. And we've got classes and community, so it's pretty cool. Thank you all so much for being here today. I'll be back next Thursday, and Tracy will be on Monday. Jessica, did you have another question?
Nope, just saying thank you.
Okay, hey, you're
Yeah,
welcome.
thanks.
Bye.
Bye-bye.
Thank you, Billy. See y'all.